notably under IPC. So IPC provides for the punishment of the offenses. Okay, IPC, that is Indian Penal Code, provides for the punishment of offenses. For example, if you commit murder, what will be the punishment? But what will be the trial process of the murder proceeding is provided under CRPC and currently under BNSS. Okay. Please make a note somewhere that BNSS is equal to CRPC, BNS is equal to IPC. Please make a note. Yeah. The majority of the code's provisions are retained in the bill. Key changes proposed under the bill include, so all the things that were under the CRPC, same thing has been copied under BNSS with slight changes. Now we will look into what are those slight changes. First is detention of under trial. So according to the code, if an accused have served half of the maximum length of imprisonment for an offence in detention pending investigation or trial, he must be released on personal bond. Okay, hello. So this provision was not available under CRPC, but this provision is available under BNSS. So if an under trial prisoner has served half of the sentence means if the sentence period was for a period of 10 years and he has served the sentence for 5 years, then he may be released on personal bond. But this section does not apply to the crimes punished by death. So for example, if the punishment is death penalty, then this provision is not allowed. Okay. Now according to the bill, the provision will not apply to the punishment of offences punishable under life imprisonment. Anyone charged with more than one offence, it gone to say that first time offenders will be released on bail after they have served 1/3 of the maximum jail sentence can be imposed for the offence. The superintendent of the jail where the accused is being held must file the application for the bail release of such under trial. Please underline. So the person will not file. The superintendent of the jail will be the person who will be filing for them. Now trial in electronic mode. This is very important. Please underline. This was not available under the old criminal procedure code. So trial in electronic mode. So all the trials, inquiries and proceedings may be held in electronic format according to the bill. It allows the use for the manufacture of electronic communication device which are likely to include digital evidence for the use of investigation, inquiry or trial. Electronic communication encompasses communication via technologies such as cell phones, computers and phones. So what before used to happen, the electronic evidence, for example the recordings of the mobile phones, were not given more importance, because when we see old times, not all the people were having mobile phones. But when we see the current situation, one incident take place and the entire thing is getting recorded by the camera of each and every person. Okay, so with that of a view, this concept of electronic evidence have been inserted under the new criminal procedure code, that is BNSS. Okay, yeah. Then medical examination of the accused. So in certain circumstances including rape, the code also allows for the medical examination of the accused. Not only the victim but also the accused. Matlab the person who is also committing the offense, he will also be getting examined. A registered medical practitioner conducts such examination at the request of at least one of the sub-inspector level police officer. According to the bill, any police officer may seek such examination. This is done to understand the matter, why he committed that offense. Okay, for that very reason the medical examination is conducted. Next is forensic investigation. So the bill requires forensic investigation for the crimes punishable at least 7 years in jail. In such circumstances, the forensic professionals will go to the crime scene, collect forensic evidence and will record the process on their cell phones or other technological equipments. If a state does not give the forensic center, then it must use one in another state. Yeah? Hello? Any doubt? Hello? Yeah. Then power to prohibit carrying arms. So the district magistrate has an authority under the court to prohibit the carrying of arms in any procession, mass drills, or any mass training with the army in public places. This may be done to maintain public order, public peace, or public safety. Such restrictions might last up to 6 months. The provision, however, was not notified under the code. The provision is not included in the bill. So this also prohibits of carrying arms. Then signature and finger impressions. This is very important. Okay, please underline. This was before also, but with certain modifications they have introduced. Okay. Yeah, so a metropolitan or a judicial magistrate can require anyone to furnish the specimen signature of their handwriting under this code. An order of this type can be issued for an investigation or procedure under the code. However, such a specimen cannot be obtained from some person who has not been arrested as a part of inquiry. So this is extended to the bill to include the finger expression and vocal samples. The samples could possibly come from some person who has not been arrested. Okay. Then this is very important. Please underline timeline for procedure. So the bill establishes for certain procedure. For example, medical examination, examiner who examines rape victim must deliver their result within 7 days. Please underline. Then other deadlines includes rendering a decision within 30 days from the conclusion of argument. For example, if in the criminal court I have concluded my argument, so within 30 days from the date I concluded the argument or the advocate concluded the argument, the court has to render the judgment, means deliver the judgment. Okay. Hello? Yeah, informing the victim of the progress of investigation within 90 days. For example, if a case is registered against me, then within 90 days, charge sheet against me should be submitted by the police officer to the court. They cannot delay in giving the charge sheet after 90 days. You know, there is a provision. If they delay for more than 90 days in providing the charge sheet, then I will be released from that crime. So what these police officers will do, at 59th day or 60th day, they will just submit the charge sheet. Okay. So this is the general practice. Then next is framing of charges by the session courts within 60 days of first hearing on such charge. For example, a charge is made. What you are telling, I am not getting. Hello?
After timeline for this. No, you can hear me?
Yeah.
So next paragraph is after timeline for procedure. Next paragraph is trial in absence of offender.
Yeah. No, I'm dealing with that only currently. Okay. I am in a timeline for procedure only. You can see the second last line, framing of charge by the session within 60 days of first hearing of such charge. I am there. Okay. Yeah. So next topic is trial in absence of offender. Okay. So even if the offender is not present, the trial will continue. So in the absence of a proclaimed offender, the bill provides for the conduct of trial and rendering judgment. This shall be done when such person has fled to avoid the prosecution and there is no immediate chance of apprehending him. A proclaimed offender is someone who is accused of an offence punishable for at least 10 years in jail or death, or fails to appear at the time or place that is established by the court. So they are considered as proclaimed offender. Proclaimed offender means one after the another they are committing offences without stopping. So the court will recognize them as proclaimed offender, repeated offenders. Okay. Then metropolitan magistrate. So the court gives the state government the authority to designate any city or town with the population of more than 1 billion 1 million as a metropolitan region, and metropolitan magistrate serve in such districts, and this provision is not included in the bill. Okay.